What happens when a judicial nominee, an expert in criminal law, is asked a simple question about the justice system and can't or won't answer? It reveals a deeper conflict playing out in courtrooms and district attorneys' offices across the country. This isn't just about one person's confirmation. It's about a fundamental disagreement over the very purpose of law and order. Is a prosecutor's job to enforce the laws as they are written, or to rewrite them in the name of social justice? Let's look at the key exchange that reveals everything.
Thank you, Mr. Chairman. Judge, Counselor, congratulations. Counselor, in about 60 seconds, because I only have 5 minutes, could you tell me, in your opinion, what, if anything, is wrong with the criminal justice system in America?
Senator, thank you for that very broad and very important question.
You're welcome.
I understand that there are numerous issues involving the criminal justice system that are the matter of vigorous debate in the public.
Give me two. Give me two things that you think are wrong with our criminal justice system.
Senator, I truly respect the role of policymakers in considering questions like this. It involves so much study of empirical data.
Counselor, I understand that. But give me two things. Maybe you don't think anything's wrong with it, but if you could give me two things you think, in your opinion, are wrong with our criminal justice system.
Senator, in my 12 and a half years of practice in post-conviction law, I have observed instances where individuals were denied fundamental rights that were defined in the Bill of Rights. And I, in many cases, have been able to assist those individuals in seeking vindication.
Okay, let's move on, Counselor. Do you think it's appropriate for a prosecutor to decide not to prosecute certain classes or lines of criminal law violations in the name of social justice?
Senator, I have not had the opportunity to review the legality of challenges to an executive's.
I'm not asking your opinion about the legality. Some of our DAs, you've read about them, I'm sure, in Philadelphia, Los Angeles, for example, other places, have said we are going to ignore criminal statutes passed by the legislature and not prosecute certain lines of cases in the interest of social justice. And I'm asking your opinion about that.
Senator, I do not actually have an opinion about that per se. I do recognize that constituents.
Counselor, you're an intelligent person. You spent your life in involved in criminal law. You don't have an opinion? Have you thought about it?
Senator, I'm not sure which specific instances of categories of crime that are not being prosecuted you're referring to.
Sure. How about shoplifting? How about receiving stolen property? How about resisting arrest? How about making criminal threats? Do you think those are all statutes, criminal violations? Do you think it's a very simple question, Counselor. Do you think prosecutors should decide in the name of social justice not to ignore these criminal violations? Have you thought about it?
Senator, I can't say I have.
You're telling me you've not given any thought to this?
Senator,
None whatsoever.
Thank you.
Counselor, I don't believe you. I'm sorry. I just don't believe you. You're a well-read, intelligent person. And I don't know why you won't give me your opinion on this.
Senator, I've focused on specific criminal cases as an advocate, appointed counsel.
I know that, but I'm asking your opinion. I'm going to ask it one more time. Do you think prosecutors should ignore criminal violations as per statutes passed by a legislative body in the name of social justice as a matter of class of cases?
All I can say, Senator, is I believe that prosecutors have a very important job. And that
I agree. Their job is enormously important. I'm just asking you to answer my question. I can't vote for you if you're not going to answer my question, because I don't know what position you're going to take if you're on the court.
Thank you, Senator.
Would you answer my question?
I would hope that prosecutors would use all of their tools and resources to make important decisions about issues such as the one that you've raised. And if confirmed, I would review the legality of any challenge.
Counselor, I'm very disappointed. I'm getting word salad here, and I don't even have dressing on it. We both know what I'm talking about, and I think your refusal to answer gives me the answer. With all due respect. Thank you, Mr. Chairman.
Thank you, Senator Kennedy. I'm going to comment on your question.
Well, I'm going to want to respond.
I want you to.
Okay.
Attorneys and prosecutors make decisions every single day as to what cases will be prosecuted and which cases will not. It is physically, legally impossible to prosecute all cases. They establish priorities. They try to serve the public in establishing those priorities. Every prosecutor makes that choice. They can't prosecute every possible violation of the law. That's just part of their responsibility. I don't see why that is a reflection on whether or not you agree with their choices or not. Some are going to take a much different view than others. That's just the nature of it. And in terms of summarizing what's wrong with the criminal justice system in 60 seconds, challenge any one of us to do the same.
Well, Mr. Chairman, you know, Dick, the affection that I have for you. But this is the third hearing in which you've made editorial comments about my questions.
But I'm leaving the floor open to you.
So I want to respond. Number one, this very bright person has spent her life in the criminal justice system. I don't think it's unreasonable to ask what, if anything, she thinks is wrong with it and get a candid answer. Number two, of course you're right about prosecutorial discretion, but you and I both know that's not what my question was about. We have a number of district attorneys that have taken the position that they are going to ignore criminal statutes passed by a legislative body, and they are not going to prosecute, they meaning the prosecutors, an entire line of cases, for example, shoplifting, receiving stolen property, resisting arrest in the name of social justice. Now, Mr. Chairman, we both know what I'm talking about, and so does the witness. And I don't know why she won't answer the question, and that's the point I was trying to make. I mean no disrespect to either of you, but I think my questions are perfectly appropriate in this environment.
Thank you, Senator. Anything more to add at this point?
The strategy employed by the senator is a classic cross-examination technique. He starts with a very broad, philosophical question. What, if anything, is wrong with the American criminal justice system? When the nominee gives a vague, non-committal answer about respecting policymakers, the senator immediately pivots. He narrows his focus to a highly specific and controversial issue. Prosecutors who publicly declare they will no longer prosecute entire categories of crime like shoplifting, resisting arrest, or receiving stolen property. This isn't a random question. It's a precise tool designed to test the nominee's core judicial philosophy. He is trying to determine if she believes the role of the justice system is to apply the law as passed by the legislature, or if she sides with a more activist view where prosecutors can selectively nullify laws they disagree with. The nominee's responses are a case study in strategic avoidance. She repeatedly deflects by stating she respects the role of policymakers, that she hasn't reviewed the legality of such challenges, or, most astonishingly, that she simply hasn't given the topic any thought. For an attorney with 12 and a half years of experience in post-conviction law, this claim stretches credulity. and the senator calls her out on it directly, saying, "Counselor, I don't believe you." Her refusal to engage is itself the answer. It signals an unwillingness to affirm the principle that laws passed by elected representatives should be enforced, which is precisely the answer the senator was seeking. This entire exchange hinges on a crucial distinction that the chairman's later comments attempt to blur. He correctly states that prosecutors have always used prosecutorial discretion, meaning they make daily choices about which individual cases to pursue based on the strength of the evidence and limited resources. But that is not what the senator was asking about. He was asking about a blanket policy to ignore an entire class of criminal violations, not on a case-by-case basis, but as a matter of principle. This is the difference between a police officer choosing not to give a ticket for going 1 mile over the speed limit and a police chief announcing that the department will no longer enforce speed limits at all. The first is discretion. The second is the unilateral creation of new policy, stepping into the role of a legislature. The key themes the senator forces to the surface are therefore not just about crime, but about candor, the separation of powers, and a nominee's fundamental judicial philosophy. This hearing room debate has profound real-world consequences. When entire classes of crime are no longer prosecuted, the impact is felt immediately on the street. For small business owners, it can mean absorbing endless losses from shoplifting with no recourse. For communities, it can mean a breakdown in public order when crimes like resisting arrest are no longer seen as serious offenses. This policy shift effectively creates a new set of rules, where the law on the books is different from the law in practice. Think of it like a contract that everyone has agreed to. If one party suddenly decides they are no longer going to abide by certain clauses they don't like, the entire foundation of the agreement begins to crumble. This is the larger issue at stake. Whether the foundation of our legal system is a set of rules that apply to everyone, or a set of guidelines that prosecutors can adjust based on their own ideology. So, what are the key takeaways from all of this? First, the exchange was a masterclass in political questioning, using a specific issue to reveal a broader judicial philosophy. Second, the nominee's strategy of total avoidance, likely intended to prevent a controversial soundbite, ultimately backfired by creating a serious question about her candor and core beliefs. And third, this conversation highlights the critical national debate between traditional prosecutorial discretion and the new trend of prosecutors acting as policymakers, effectively repealing laws from their own offices. This leaves us with a critical question. Was the nominee being prudently cautious in a high-stakes confirmation hearing, or was her refusal to answer a deliberate evasion of a fundamental legal principle? And more broadly, should prosecutors have the power to ignore laws passed by our elected representatives? What do you think? Let us know in the comments below. And if you found this analysis helpful, be sure to like, subscribe, and share this video.